A courtroom battle erupts when one defendant's repeated legal mistakes push a judge to the breaking point. Warnings were ignored, filings were challenged, and patients inside the courtroom began to disappear. But as the judge demands accountability, every excuse is put under the spotlight. Stay until the end because this hearing reveals how quickly courtroom decisions can change everything.
And then I'm going to do what I was going to do 5 minutes ago.
Good afternoon, Your Honor. Plaintiff Anthony Momena appearing on behalf of plaintiff.
Good afternoon, Your Honor. Azara Stafford.
Your interpretation. In this case.
Your Honor, I'm not quite sure. Last time we appeared in the court had advised the parties to reserve all the documents that had been served because of some last pleadings the defendant filed. I haven't received any additional pleadings from them. We did file an answer to those pleadings. I do notice that I pulled the docket today, and there is, as of today, some reference to a dismissal with prejudice. And I'm not quite sure what that would mean in this.
Well, the problem is, and I don't. Okay. You've not received any documents that you attempted.
Nothing
So,
since the original delivery that I placed on the record.
At the last hearing, I struck all of the documents that had been filed by the defendant in this case because she had changed the caption. They were to be refiled and served.
They were not.
Was that done? Ma'am?
Yes,
Was that done?
Your Honor, first of all, we have not been.
Ma'am, I asked a yes or no question.
Yes, Your Honor, we served the plaintiff with the joinder we filed and in federal court. We did. The plaintiff did not send us any pleadings. I have not received any complaint. I have not received, he has not followed the rule 5.108 of 7-day notice that he has to give me. He is in violation of professional responsibility, rule 7 and 8. We have not received any complaint, or he cannot produce proof of service to us, Your Honor. But we can provide proof of service that he was served by sheriff for federal claim.
Let's try this again. The last time that you were here, I told you that you had improperly changed the caption on the pleadings. I struck those pleadings, told you that you needed to refile them with the correct caption and serve them on opposing counsel.
Yes, we,
My sole question to you is,
okay.
Did you do that?
Yes, Your Honor.
Did we get a new filing? Yeah, because if she filed them and served them, they would be in my court file. And it's odd. I don't see new filings in my court file. And I don't see, and counsel's indicating he didn't get it. But she's telling me she didn't.
So according to JIS, today an answer and motion to dismiss was filed.
That was.
Not by me, Your Honor.
Yes, okay, I see that. But that was not the original.
I have not seen that.
Service on here. I don't. I still have Carl Staffield on this case, and I don't know why.
Because he's a resident too.
needs to properly join the case. I don't. You did it again. The caption you just changed.
May I speak, Your Honor?
Yeah, go ahead. We did the same thing we did the last time.
And may I show this to your,
No,
this,
you did the same thing.
no, this notice to appear is only addressed by the plaintiff for my daughter only, who is out of town, and we received it in the mail yesterday. And it doesn't even have my name on it.
Who filed this dismissal?
We did. I did.
You're not the plaintiff.
I'm a counter plaintiff.
Then how do you give me a notice of dismissal regarding this case
That was
and not sign it?
I'm sorry.
You filed a dismissal of the case under the section notice of dismissal by plaintiff. You are not the plaintiff.
I am a counter plaintiff, Your Honor.
I am not accepting any of these pleadings until you get the caption right. I'm not accepting these sort of random documents coming in as a dismissal, a notice of dismissal. The only thing that you would be entitled to dismiss would be to the extent you believe you have a counterclaim. That's the only thing you're going to dismiss. You can't dismiss his claim.
Yes, Your Honor. May I say one more thing, please?
Go on.
My grandmama died, and we are flying out of US next week to attend the funeral. If you want to.
I'm not going to allow you to continue to delay these matters through some improper procedures that you're employing. I'm not going to let that happen. My condolences on your loss, but I'm not going to just continue to lay this matter out to have you continue to do the same thing.
What am I doing wrong, Your Honor?
I have already told you what you're doing wrong. If you don't think you're doing anything wrong, then maybe you need to get an attorney
Okay,
that's licensed to practice
okay,
to do this.
okay. Could we have next hearing after April 1st, please?
I'm not going out that far.
Your Honor, this is the third appearance in this case.
Oh, I know.
You gave her 2 weeks after the last appearance.
To get everything right, and
And you admonished her to get an attorney at that point.
I did.
Yes.
Striking those pleadings. Don't file anything else that's improper and not properly filed with this court. I'm just going to be that direct.
Okay.
Matter will adjourn to March 21st, 2020.
If I may, Your Honor, briefly, just briefly, this is not a rent case, Your Honor. This is
Oh,
a
I know.
termination of tenancy. The lease has been up for 60 days. She's staying in there. There was an escrow order that was filed. To our knowledge, she hasn't paid the rent. To our knowledge, she didn't pay the jury fee. To our knowledge, all these things have happened, and my client is being prejudiced by the moment here. There's damage occurring to the premises. There was construction and landscaping that was violative of the city ordinances and the HOA standards. We have a witness here today to testify that the property is being damaged as we speak, and we need.
What way?
There's significant runoff and sediment runoff. That the backfill was backfilled 4 feet to 5 feet to more over the base of the trees in the backyard, and that's been that way for some time. The fact of the matter is she's had more than, I'm defer to the court, of course, but she's had more than an opportunity. She's filed this federal suit She's doing everything possible to delay our occupancy. And I just don't think it's equitable or right. It's up, of course, your decision, Judge.
Oh, I know.
She knows well what she's doing to buy time here. And she served all these pleadings. She claims she doesn't have an attorney. I read the pleadings. They were drafted by somebody other than her, it appears. She hasn't followed one rule. She hasn't served me once correctly. The person that's named in incorrect caption isn't even a tenant on the lease. I don't know where they came from here, but they're non-party. My clients had to pay me to come in here and deal with all this sort of thing. And they've joined us in a federal case that names almost verbatim the same cause of action that's named in this very counterclaim that the court struck and apparently dismissed with prejudice. All I would ask the court is that I possibly could get if she wants to appeal this, and I would pretty much bet she's going to when the time comes. Let's get that process started if at all the court would go along with us. Let's get a judgment for possession entered. We can give them a little extra time if they want to put in the appeal period and get us our judgment. And then she can do what she's going to do anyway when she gets her day in court, according to her. She's been here 3 times. I've traveled from Oakland County.
I'm sorry to hear that.
3 different, yeah, me too. 3 different times to be here, Judge. None of what she files makes any sense. And it's just not right on my client's behalf to let my client continue to suffer while they occupy the premises without any consideration. She's going to appeal this if we win, and we probably will. The point being, let her appeal. Let's get that process started if that's what she's going to do. Thank you, Judge, for listening. Yes.
Okay, good.
I want to answer.
Go ahead.
Your client, sir.
No, you will address me.
Okay, I apologize. His client, Your Honor, is a loan shark who bought our property in a redemption period and signed an agreement to let us buy this house back from him. We are ready to go ahead buy this house back, but while his client was owning this place in last 9 months, the Barton Village put a lien on the property. Now we cannot get a mortgage because they have a lien on the property. And by him in this court trying to put me down because I'm representing myself is also another violation of
No, you need to talk to me.
Yes.
Go ahead.
Okay. Your Honor, we have served everything. This gentleman cannot provide one proof of service to this court. He gives us papers last minute. We received this in the mail yesterday. He did not serve us properly.
That was the escrow order only.
Okay. I'm sorry. Please don't interrupt me. Thank you very much. I didn't interrupt you when you speak. Extend me the same courtesy. Okay? This loan shark and his attorney are trying to...
Are you almost done?
Yes, to take us out of our home. And they put a lien on that house. So now we can't even get a loan to purchase the mortgage to purchase the property because it has a loan. Now he's asking us for the possession. We paid the rent, but the rental agreement is over. We want to buy the house. The lien doesn't let us buy the house, Your Honor.
I would ask for one brief moment to respond to that. If the court wishes to.
Why are we doing this? Okay, so here's what happened. I told you what I was going to do.
Enough said.
You wanted to talk, then you wanted to respond. And now you want to go back and guys want to spend all day going back and forth. Tell you what, we can put you over there on the side. I can handle all these other people's cases so they don't have to sit through this. I'm required to. And you guys can just go back and forth, and then I'm going to do what I was going to do 5 minutes ago.
Thank you, Judge.
Okay.
Hearing nothing else, March 21st, 2025, 2 p.m. You get the pleadings right or get an attorney in here. Thank you.
Thank you, Judge.
Ma'am, you're not gonna yell when you're in here. You're not gonna whisper under your voice. I don't operate that way. Understood? No. Understood. I heard you all the way up here. Have a great weekend.
Thank you, Judge.
Can do me a favor, can you go out there and just make sure they don't like,
Johnny,
okay, no, I did that the last time. You were much nicer about correcting me this time, but come on.
Good.
Said it nice this time. The last time it was like I had insulted her whole family. Anyway, go ahead.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Martin. Ms. Martin, please state your name again.
Johnny Martin.
Chris Ware on behalf of probation. Your Honor, Ms. Martin is before the court for a violation of probation hearing. Ms. Martin has been on probation for 2 years for a reduced charge of assault and battery. In this case, Your Honor, Ms. Martin has made no payments to the court. Her balance is $1,530. Probation has failed to receive completion of the CPS Family First Program and Parenting class. Ms. Martin also failed to report to probation after April of 2024. And Your Honor, her probation term is maxed in this case. Given that these items were not completed, probation is recommending that Ms. Martin serve 93 days in jail with credit for 1 day served, that she serve the balance, waive remaining terms, accept the financial obligations, and discharge her from probation.
Ms. Perry.
Your Honor, I was able to speak with Ms. Martin about these issues. She believes that she did complete the CPS and parenting class. She's been trying to get in touch with them for the last week or so to get proof of that. She has called the case manager that was on the case. She no longer works there. She gave her another number at CPS. They told her they would call her back. It's kind of she's been, thwarted by bureaucracy. So I'm asking to adjourn this hearing out a bit so she can continue working on that. Again, she remembers completing it, but it has
Why
been.
didn't that information get to probation?
Frankly, Your Honor,
I can tell you why, because she never reported to probation.
she did. That is the allegation, Your Honor. Around the time that this was all happening, the father of her 2 youngest children was killed in Washtenaw County. And I think she's a single mother. That kind of, greatly affected her life. And she's been dealing with the repercussions of that since that happened in June of 2023. So she wants to get proof to probation. She's just having trouble doing so.
What about payment? I have no payment. I have no reporting to probation. I have nothing.
I just started working out.
She has 5 children?
Yes.
5 children, 11, 8.
11, 9, 8, 3, and 1.
So she, for a long time, didn't have childcare to care for her children and work.
I just started working. I can't make a payment when I get my check. It's
How come you
hard.
didn't report to probation?
I don't know. I had after my child's father passed away at my apartment complex, I just shut down. It was real hard on me.
I get all that, but I guess the last time you were before the court was in February. You're going to pay the fines and costs by March 3rd. No payments. You would report to probation. No reporting to probation. I'm assuming you were supposed to complete the Family First program and parenting classes. I don't have any proof of any of that.
As I completed it, I went to Orchard's Family, Children and Family Services. I think that's what it's called.
When?
I finished that class in 2023. I just didn't report it.
So you're saying that was completed before I sentenced you?
Yes.
Runner, I can try to look to see what the prosecutor's office may have.
What the prosecutor's office may have?
Yeah, I mean, maybe it was provided to them to reduce the charge, as this charge did originate as a child.
Anything else from anybody?
Nothing from me, Your Honor.
Do you have anything else you want to tell the court?
I was just give me some time to like make the payments. Like I'm all my kids got. Like I don't really want to go to jail. I'm already have.
Should have been keeping in track with probation.
Right.
You just didn't do anything.
I know that I did the. Excuse me, I know I did.
Okay, so here's what I'm going to do. I'm going to waive the remaining terms except for financial obligations. I'll discharge her from probation without improvement. What I am going to order is that she's to serve 93 days in jail. I'll give her credit for the 1 day. She's to serve the balance. I will strongly consider release if I get proof of completion of that class. All right, you're still going to owe the money. You need to set something up with the court. You're going today, but if they get me proof of that, then I'll consider release. I'm not guaranteeing that I'll release you, but at least I could have something to look at that says you did something.
Okay, can I at least call? Can we call the people?
Call which people?
For the.
You can talk to your attorney. We can figure out a way to make the call, but right now you're going. Defendant's remanded. Court calls the case People versus Chance Stallings.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Stallings, who stands to my right. Please state your name for the record, sir.
My name is Chance Stallings. Good morning, Your Honor.
Teresa Clare on behalf of probation. Your Honor, Mr. Stallings is before the court for a violation of probation.
You take your hands out of your pockets. Go ahead.
Mr. Stallings is non-compliant with the terms ordered by this court in that he owes a balance of $1,725. His last payment to this court was made in January of 2024. He failed to provide proof of substance abuse treatment. He failed to provide ongoing proof of mental health treatment. Mr. Stallings, to update the court, did provide me with some documentation, but that was dated in 23. So it's nothing that is updated or a status report that anything continued. He failed to report to probation as directed. He would contact me sporadically throughout the term, but nothing consistent like he was supposed to. Mr. Stallings also has a new pending criminal case of domestic violence and an assault out of Toledo. That alleged date of offense was February 20th of 2024. He failed to appear on that case and is in bench warrant status there. He has maxed the 2-year term in this case. Given all the violations before this court on this matter, probation is recommending that Mr. Stallings be remanded to serve 365 days in jail with credit for 77 days served, that he serve the remaining balance, that he complete the in-jail Dawn Farm program, waive remaining terms, accept his financial obligations, and discharge him from probation without improvements.
Response.
Thank you, Your Honor. I have had, of course, the opportunity to review the allegations as well as the recommendation and discuss them with Mr. Stallings. I guess I will just address each one by one. We do acknowledge that there is that balance owing. My client states that he could make the payment in full today. We do also acknowledge that the substance abuse treatment was not completed. However, my client does state to me that he has been on his own attending NA meetings and that he is on a waiting list through his insurance for the mental health to get into the substance abuse treatment program. He relays to me that he's been on a waiting list for almost 2 years. He did provide that documentation from 2023 that Ms. Polero referred to. We do acknowledge that the reporting has been sporadic. Mr. Stalling states to me that during his time on probation, he experienced homelessness for quite some time. So he often didn't have access to a phone, or he didn't have an ID to be able to go to the library and use their computer to try to do the online monthly reports. He does acknowledge, and there's no arguing that, yes, his reporting was very, very sporadic. And he does acknowledge that a lot of it was because of his housing insecurity and homelessness. He does also acknowledge that there is that new case. As of right now, they are just allegations, and he does believe that he will be found not guilty upon the resolution of that case. Ultimately, we're asking that the court, when I do also want to mention, my client also suffers from narcolepsy, and he has been applying and trying to get SSI. We are asking that the court, because we do acknowledge that the probation term here is maxed. I'm asking the court to discharge him from probation without improvement, waive the remaining terms outside of the financial, which he states he could pay the balance in full today, and not impose the jail time, given the fact that he has dealt with some serious housing insecurity and does have a health issue. And in the alternate, if the court was to impose the jail time, I would ask if the court would consider early release upon the completion of that in jail Dawn Farm program. Outside of that, Your Honor, that would be my request.
Anything you want to say, Mr. Collins?
Your Honor, I had a pretty unbalanced last 2 years. The first year I was pretty decent with reporting and keeping updated with Ms. Polero. Once I fell into homelessness, I really fell off track. I've recently started improving again. I have a job I work at. I recently got a tax refund, which is why I'd be able today. Your Honor, the defendant in that case is present in the courtroom, and we're the one that's out of Toledo. We're working on getting it dropped. It's just a really tedious process with the clerk's offices out there. She's trying to contact the prosecutor to set up an account. As I said before, I'm just trying to be a better man for my kids, and I understand that I have and take accountability that I haven't been in full compliance with reporting. I've been doing the best that I can, Your Honor, and I'm at your mercy.
Well, there's not a lot else I can do. I will order that he, once remanded, is to complete the in-jail Dawn Farm program. I'll consider maybe circumstances of his release at that point in time. I'm going to waive the remaining terms, except for financial obligations, discharge him from probation without improvement. I am going to sentence the defendant to 365 days in jail, credit 77 days served. Defendant at this time is to serve the balance. Defendant is.
Today's courtroom battles proved one thing: excuses can only go so far when the law demands accountability. From improper filings to probation violations, every decision came with real consequences and lasting impact. What would you have decided if you were sitting in the judge's seat? Let us know your thoughts below. Like, subscribe, and join us for the next courtroom showdown, where every ruling tells a story.